Good morning once more, everyone. Sorry for the delay, technical hitches, but here we are, Licensing Subcommittee on the 5th of February 2024. It is now 10:43, I make it. Good morning, everyone. My name is Councillor Macpherson. I'd like to welcome you all to Cambridge City Council Licensing Subcommittee meeting. To my left is Councillor Pounds, to my right is Councillor Wade, and what I'd like to do is to go to the legal representative and ask for a formal election of chair, please.
Yes, I'm happy to propose Councillor Macpherson as chair. Do you second the proposal?
I do.
Thank you, everyone. I'll now move on to introductions. Rather than me read all the introductions, I always find it's much more pleasant for people to introduce themselves. So if we could just start with yourselves, just introduce the officers, introduce themselves. Members of the public is fine, and we'll go from the side.
Yeah, Alex Beebe, licensing officer.
Stacey Grundy, licensing officer, Cambridge City Council.
Elizabeth Lamahin, legal advisor.
This one's working. Graham Goodwill, counsel for the applicant.
Valmer Davutoz, application agent.
Councillor Imogen Blackburn Horgan.
Okay, I think we've got everybody, I do believe. Okay, in that case then, hopefully there'll be no more issues. If a fire alarm should sound, that will be a real one. And in that case, please follow the officers to the relevant exits. The licensing officer, if I could ask the licensing officer first to present the report, but first I will ask the applicants and Mr. Goodwill if you're happy with the procedure, which is on page 3 and 4 of the report, and if you're happy with the procedure, or if you wish me to go through some of those items. I'm sure you don't, but I'd like to give you that opportunity.
No, we're content to proceed.
Okay, thank you very much. In that case, if the officer would like to present the report, thank you.
An application under Section 17 of the Licensing Act 2003 to apply for a premises licence for the sale by retail of alcohol with respect to Sunset Lounge, 106 Cherry Hinton Road, Cambridge, CB17AJ, has been received from Valmer Davutoz. The application was served on Cambridge City Council, the licensing authority, on 13th of November 2023. A copy of the application was also served on each responsible authority, and you will find the application attached to the report as Appendix 1. The applicant is seeking to provide the sale of alcohol only for consumption both on and off the premises from Monday to Saturday between the hours of 11 a.m. to 10 p.m. The representation date was reset on 11th December 2023 due to the licensing authority becoming aware that the original plans submitted with the application were incorrect. New plans, which are attached as Appendix 2, were submitted on the 9th of December 2023, which included the rear extension, which is now shown on the right side of the plan. In accordance with the regulations of the Act, the application was advertised on the premises and in the Cambridge Independent newspaper on 20th December 2023 to invite representations from responsible authorities and other persons. The last date for submitting representations was the 8th of January 2024. Representations were received from 4 other persons, and you will find those attached to the report as Appendix 3. The application, therefore, needs to be determined. Recommendation that members determine the application on its individual merits, having reference to the statutory licensing objectives and Cambridge City Council's statement of licensing policy. Background. The premises was previously Palki Bengali Takeaway. The business was closed on environmental health records back in July 2023. The Planning Authority has provided some additional comments on the application, and you will find those attached as Appendix 4. This submission was not considered a representation as it did not relate to one or more of the licensing objectives. The comments have, however, been included in the report in order to give background regarding the current planning issues, principally concerning the rear structure. The premises does not fall within one of the cumulative impact areas. In carrying out its licensing functions, the Licensing Authority must have regard to its statement of licensing policy, and additionally the statutory guidance issued under Section 182 of the Licensing Act 2003. The relevant sections of the Council Statement of Licensing Policy are Objectives, Section 2, Fundamental Principles, Section 4, Licensing Hours, Section 6, and Licence Conditions, Section 8. Consultations. The Licensing Act 2003 requires applications made under Section 17 of the Act to be served on the responsible authorities and also advertised on the premises and in a local newspaper circulating within the vicinity of the premises. During the consultation period, responsible authorities and other persons, which can include any individual, body or business entitled to make representations to licensing authorities, may make a representation in respect of that application. Statutory consultation has therefore taken place with the responsible authorities and interested parties in accordance with the procedures set out in the Licensing Act 2003 and associated regulations made under the Act. Options. Whilst having reference to the information provided by the applicant, the information raised in the representations and also Cambridge City Council's statement of licensing policy, the subcommittee's decision must be made with a view to promoting one or more of the 4 licensing objectives, namely the prevention of crime and disorder, public safety, the prevention of public nuisance, and finally the protection of children from harm. Members should take such steps that they consider are necessary for the promotion of the licensing objectives. The subcommittee may therefore resolve to A. Grant the licence subject to the mandatory conditions and those conditions offered by the applicant, which may be modified to such extent as the authority considers necessary for the promotion of the licensing objectives. B. To exclude from the scope of the licence any of the licensable activities to which the application relates. C. To refuse to specify a person in the licence as the designated premises supervisor. Or D. To reject the application. Whichever decision members decide to go for, they must give their reasons for doing so. Conclusions. The Licensing Authority has a duty under the Licensing Act 2003 to promote the licensing objectives. Each objective has equal importance. In carrying out its licensing functions, the Licensing Authority must also have regard to its statement of licensing policy and the statutory guidance issued under the Licensing Act 2003 and is bound by the Human Rights Act 1998. The Council must also fulfil its obligations under Section 17 of the Crime and Disorder Act 1988 to do all that is reasonably possible to prevent crime and disorder in Cambridge. Thank you.
Thank you very much for that. Councillors, do you have any points of clarification for the officer? No, you're okay. In that case, Mr. Goodwill, do you have any points of clarification for the officer? Do you have any points of clarification you wish to? No. Oh, so you're okay at the moment. Okay. Yeah, please.
In relation to the licensing, you said they would only be licensed until 10 p.m. on weekdays. Is that correct?
Monday to Saturday, so I understand.
Okay, so why is dancing being advertised from 10 p.m. and neighbours have informed councillors that customers are leaving at 12 p.m?
So in relation to the dancing, it's not considered a licensable activity between the hours 8 and 11 due to deregulation of the Act. Also, opening hours are not considered enforceable under the Licensing Act 2003. So from the Licensing Authority's perspective, we would be looking at any contraventions after 10 p.m. of licensable activity being undertaken. After 10 p.m, that is not going to be within the remit of the licensing authority.
Thank you. You said that they had to put up a sign saying that they were going for the licensing, and that had to be up for a certain amount of time. So why did a resident have to report that that sign had gone missing before the stated time had elapsed, and then it was only put up a few days afterwards?
So as I understand it, there was an email which was received from a resident who said that the notice was not on display. This was, I don't have the date of it. I can find it if you like. A photo was sent through from a local resident and the notice wasn't on display. We'd previously had confirmation of the notice being on display because applicants have to do that, and we accept that by photo. I immediately contacted the agent who the applicant had at the time. They said it was due to the windows being cleaned and they had taken the notice down. The notices were then put up almost immediately. So from my perspective, I can only evidence that they weren't up on Friday, but I understand the resident said that they were not up for longer. However, on reflection, the licensing authority felt that was not significant enough to reset the representation period and that it had been adequately dealt with by the agents and applicants.
Okay, thank you very much for that. Councillor Smith?
Yes, thank you, Councillor McPherson. Can you hear me okay?
Yeah, receiving loud and clear, thank you.
Thank you. Sorry, I've just had a computer blip. Can you come back to me in 2 minutes? Apologies.
Councillor Pounds?
Thank you. I'd just like to get something absolutely clear, if I may, because there are other issues with this application to do with planning. So what we're actually being asked to do today is just to consider whether the premises, as it has been operating under licence E, isn't it? The whatever you call it, that it already has, which doesn't need to be licensable, which is up to 10 o'clock at night, and that and it's just the premises as it originally was without the extension that's been built above, and we're just being asked to say whether that original setup is what we're being asked to license to sell alcohol.
So there are amended plans which have been given in Appendix 2. That's why the representation date was reset. So you're considering the breadth, everything within those plans there and the rear extension. There has been a lot of discussion about the planning, and that is, I'm sure the legal advisor will say that it's not in consideration for today. The premises have been using many temporary event notices, which they are allowed to use, which is to clarify, there is no licence there right now. This is a new licence application. They've only been selling alcohol due to having the temporary event notices.
So you are actually asking us to consider licensing both the original premises and the extended premises?
Yes, everything which is in the plans, which is in Appendix 2 of the pack.
Thank you.
Councillor Smith, are you good to go?
Yes, I am. Thank you. I want to know why we've received documents at this late stage. It's extremely difficult to advocate effectively on behalf of our residents when we're having to look at things on email about 15 minutes before a meeting is starting.
I think that may be better answered by you, Chair.
Okay, we were in the same position as you, Councillor Smith. They were very late, and with consultation with a legal representative, we decided that in fact they weren't really material. They're photographs more than anything else. There's no statements. There's no actual text added to the report. They're just photographs of the inside and some of the outside of the building. And I believe there was a photocopy of the menu, yes there is, and also a pencil line position of the premises, and that's all it was. So we didn't really consider that that was going to be anything particularly material to affect the report that we've got before us. I hope you agree. However, I do take your point, it was late, I did mention that.
Yeah, and it does just make it hard for us to even ascertain that is something that we don't need to be too bothered about. The other question I think I would like to ask is around our confidence and the licensing officer's confidence in the terms of this license being adhered to. To refer back to Councillor Imogen's questions, residents are already reporting much later opening, much later noise than 10 o'clock. So what level of confidence do we have, given that there are activities clearly advertised for after the time that alcohol is supposed to be stopped serving, that there will actually be a cessation of the serving of alcohol at 10 o'clock, and that having served alcohol till 10, it is not going to increase noise levels quite significantly after that time because people have already had something to drink.
All I can really say on that point is that should residents, local businesses wish to complain about the premises, then we will look into that. We will investigate any complaints, any noise complaints which come in, any complaints about possible breaches of the licence in terms of the licensable hours, activities and conditions. And there is always the facility to review the premises licence following grant of the licence should members decide to do that today. And that review could include revoking the licence, adding more conditions onto the licence. But the task in front of members today is to determine the application on its own merits, the representations that have been put in today.
Councillor Wade.
Hi. Could you just take me through very quickly the scope and the protocol for a temporary event licence, please?
With a temporary event notice, it allows any person over the age of 18 to be able to apply to provide licensable activities, be it sale of alcohol, regulated entertainment, late night refreshment. But there are many limits in place about how many times a person can put in the temporary event notice per calendar year, as well as the premises. Now, there are still post-COVID increases in the amount. It used to be 21 per premises and it's currently 25. So last year, for example, there were 5 temporary event notices that Sunset Lounge put in. There's been 5 so far this year, so they've used 18 out of 25 of their temporary event notices. There is a 10 working day notice period for all what's called standard 10, and that doesn't include the day of submission and the day of the event. There's also the facility to submit what's called a late 10, which reduces the notice period to 5 working days. Then the applicant loses the opportunity to appeal against the notice should police and environmental health, who are the only 2 bodies who get notified of 10s and can object to them. The applicant will lose the opportunity to appeal against any objection.
Thank you, that's helpful. Could you tell me, within that temporary licence, are hours covered, and are there any details required of what's actually taking place on the premises regarding music, etc.?
With the application form, the applicant is able to give some details about what they're going to do, such as playing of music, it's a DJ event, it's somebody's birthday. Not everybody does. So yeah, they must supply what hours that they are going to be operating, and if that carries on over midnight, for example, then that will count as 2 days out of the maximum that they are allowed.
Councillor Pounds.
So is it possible that a temporary licence can extend beyond the sort of statutory, which is up to 22 hours, even though that the premises doesn't have an overall licence for that?
Yeah, so the temporary licence is, it kind of sort of supersedes, if you will, even if there was a premises licence, there are businesses that will have a premises licence and then also apply for a 10 for whatever reason. So the 10s you can apply for realistically whatever you want. It is then up to the responsible authorities to decide if the running of that, the operation of that 10 is going to negatively impact on the licensing objectives.
Okay, everybody ask the questions they wish. I had a couple of questions myself, but they've already been asked, so I'll keep those for a little bit later. Mr Goodwill. Oh, Councillor Smith, you've got another one. I'm sorry, I missed you. Sorry. Please carry on.
Sorry, thank you. I wonder if the officers could comment on what understanding there is of the potential impact of an alcohol licence on an already noisy premises.
One of the considerations for members is that the granting of an alcohol licence will also allow the business to play recorded and live music as part of the deregulation contained in Live Music Act 2012. For example, premises that have an alcohol licence will be able to provide amplified live music, in this case up till 10 because that's what they've applied for, and also recorded music until 10 p.m. as well. That's what having a licence allows under the deregulated version that we find ourselves in at the moment.
Okay, thank you for that.
Sorry, Chair, could I just come back on that, Chair?
Of course
So
you
my
can.
question wasn't quite that. My question was, if people are drinking, does it make them noisier? So if you already have a badly sound insulated property, does having additional alcohol being served make it even noisier than it would be if alcohol was not being served? Is that the experience of the licensing authority?
I would say we would have to deal with it on a case-by-case basis. I can't blanket say that yes, definitely it would, because there are many factors to take into consideration. If we get complaints, then we will refer those to our usual noise complaint procedures.
Okay, everybody happy to have asked all questions so far? Okay, in that case, Mr Goodwill, the floor is yours.
Thank you. Perhaps I ought to clarify some matters at the outset that may take the sting out of some of the objections that have been raised. Now, the position was that on the 17th of January 2024, an enforcement notice from the Planning Department has been served upon Mr Dortage, and it relates to essentially to the extension at the rear. And it has effectively said that, first of all, that the use of the land as a shisha lounge should cease because it's outside the existing planning. That secondly, that the rear extension ought to be demolished and the materials removed. Now, today, I'm told, an appeal to that notice has gone in, seeking permission in relation to the extension and the use of the premises as a shisha lounge. The point I make today, however, is it's the applicant's position as of today that whilst he has put in this application for a licence for the main structure of the premises and the additional rear extension, which obviously appears to be the section of the premises that's creating concern, the position is as follows, that pending the outcome of the planning appeal, Mr Dortage will not use the facilities as a shisha lounge, and in fact he will mothball the rear extension, so that for the purposes of today the application primarily is for a restaurant and on and off licence, using the main part of the premises, not the extension, and that is what we are seeking today. We are not asking today for the licensing of the rear extension. So that may take some of the sting out of objections about if this structure is not sound, there's risk of noise, etc., etc. So that's the position. Now, I'm new to this case, brought in late on. Unfortunately, Mr. Dortage has had not very brilliant advice in making his application. The extension was built on the basis of wrongful information supplied to him by a planning officer at an early stage, when the planning officer was asked about, can we put a ground floor extension on a one floor extension to the back, he was told, as long as it's not above 2.5 metres, he can do it. But of course, that advice was mistaken, because the advice given, that may well be relevant to a domestic residence where somebody is seeking to build a little extension onto the back of the house. But of course, these are commercial premises. So as a result of wrongful advice, Mr. Dortage has gone along and created the lounge that you see. But as I've said, pending the outcome of the planning appeal, pending that, his position is that the lounge out the back, the rear extension, will be mothballed. It won't be used for any drinking purposes, and the whole premises will not be used for any shisha use. Unfortunately, another problem that I've picked up on, the whole purpose of these premises is to be a restaurant, a good quality middle range restaurant. And I'm absolutely flabbergasted when I've seen the application that for some reason the application has been limited from Monday to Saturday, when quite plainly one would have thought people running a restaurant ideally would want to open it on a Sunday. So people can have a nice Sunday lunch or an early evening Sunday meal. So it may not be possible, and it may be a further problem for Mr. Dortage, but if it were possible that his application, which at the moment is from 12 noon until 10 o'clock to serve alcoholic drinks, if Sunday could be included, it would be very beneficial. It was an error made by the previous agents dealing with this matter. And I think it dates back to the fact that the previous use of the building was as a takeaway restaurant. And originally, back in 1994, which is a planning application that's been referred to in the papers, it was as long ago as 1994, originally the committee only permitted use between 7 a.m. and 10 p.m. Monday to Saturday. And it appears that those identical hours were selected by the agent. What the agent didn't take on board was that there was a successful appeal by the Bangladesh, by the takeaway restaurant in 1994, which enabled them to also operate on a Sunday, 7 days a week. So, as I say, in a perfect world, and invite you to consider whether you'd allow the application to be considered to cover Sunday as well as Monday to Saturday. The point now is this. Mr. Dortage has taken out a 10-year assignment of the lease. So it's a long lease. And he has spent in the region of £160,000 in carrying out the renovations that you see. Quite a bit of it, or some of it, obviously, is expenditure on the extension out the back. The plan is for this to be a mid-range restaurant. You've seen the menus. Starters are approaching £10, main course at £30 or thereabouts, and puddings are £8 and £9 or thereabouts. So the clientele it's seeking are good quality customers. This is not what the street, Cherry Hinton Road, this is not another Indian restaurant, Chinese restaurant, takeaway burger type food. This is top quality food. The chef was employed formerly by Lot Fine, a restaurant in Cambridge, and you can see that there's quite a lot of fish dishes on the menu. During the past 2 months, the premises have been opened on a good number of occasions under the TENS licence. And he has employed up to 8 people. The plan is that when the restaurant is fully operational, that he would employ up to 12 people. So, what I invite you to do now is to look at the photographs that were provided, and if I can take you through those. Now, page 1 shows the front of the premises, and there is some outside seating. Now, the licence has been applied for is until 10 o'clock. Consideration is being given that perhaps at an earlier hour in the evening, the outdoor eating places, people will be asked to go inside so that they don't create a lot of noise outside. That will minimise the noise. But it certainly, for nice summer afternoons, early evening, that would be a useful purpose, that people can sit outside as well as all be in the main part of the restaurant. Page 2 shows the outdoor front, and it shows what's opposite. So, quite a wide road, Cherry Hinton Road, and you can see that apart from one house on the other side, completely opposite is some form of a warehouse, and next to it is another shop. So, when you talk about residential area, I invite you to consider the actual location. Of course, there are residences around and about, but there is also a lot of mixed retail and other uses. And we say, when you analyse it, look at that photograph. Is that something where you can straight away say, my word, all the poor neighbours? Then we're talking about a middle-range restaurant for people to have a nice relaxing meal with a glass of wine. Are they, when one analyses it, look at that. Is that really something that's going to fail with objectives of being too noisy? Of course, the point I make applies a fortiori to the inside of the premises. In 1994, the issue about whether the previous premises needed soundproofing, there was no need. There was a finding made in 1994 that the person who ever occupies the first floor flat above these premises was properly protected from noise without any more. So the situation is we have inside, this is one side of the restaurant on page 3, and on page 4 we have the other side of the restaurant, nice table and chairs, nice picture on the wall. And again, page 5 shows the bar area. Part of the application says that there perhaps may be 3 bar stools for people to sit and have a drink, perhaps while waiting for a meal or to have a drink. For completeness, I've included photograph 6. This is the corridor from the back of the main restaurant, and it shows to the side door the kitchen, and you see the corridor. It's been nicely levelled to facilitate and assist disabled access. Page 7 is round the corner at the back. It shows that the building leading to the 2 toilets. And page 8 and 9 show the incredible elaborate decoration that has been put into the men's and ladies' toilets, and shows the high standards that Mr. Dortage wants this restaurant to be. For completeness, I've enclosed a photograph of what the rear extension looks like. And the decor is obviously fine. But as I've said, we are accepting that as of today, we are not asking for the licence to extend to that area. And that will have to wait to see what happens on the planning, because there's a possibility permission to vary it for a better type premises will be allowed, or there's a possibility that it'll have to be taken down and removed. But we've got to await that day. But rather than get into massive contentious issues about what noise may emanate from this structure, today we are not pursuing that part of the application. We are focusing on the main building and the front. Again, if we go on to page 11, you can see what the front of house looks like. And we've got a chemist's and estate agents to one side. There is the restaurant. And then on page 12, we have 2 other retail outlets on the first floor. We've got the mini market. That has a licence until 10 p.m. And then there's a tattoo parlour. Now, on behalf of Mr. Dortage, we say that this restaurant adds a terrific amenity to the community. The opportunity for residents from nearby streets to attend and have a nice meal. There is no parking on Cherry Hinton Road, but there is a substantial car park nearby in Clifton Road. The reality of it is, if people are coming for a meal and a drink, that they probably are not going to drive to the premises anyway. And essentially, the clientele that Mr. Dortage hopes to attract are the locals, people who can attend on foot. So what we say is that the fears and concerns about noise emanating from the building, if we focus solely on the main part of the building, as I've indicated, the front part, which is in the open air, there would be consideration to that being not fully operational late at night. Maybe that will people will be seated inside from a certain time. Again, page 13 shows opposite another convenience store, beauty salon, and then there's a large building in the background and a big car parking area. Now, page 15, this is the rear part of the premises, and it shows, this is taken from up Rock Road, and it shows the rear extension filling up the rear part of the premises. And you can see near to, at the back, there's a large heat extractor, smoke extractor. You can see, in fact, the back part of the flat 106A, which is above the restaurant at 106. And primarily, the objections to this application have come from the occupier of that flat above. Page 16, this is taken from the rear, where the previous photograph was taken. This shows the opposite side of Rock Road, shows a wide road, and you see houses 2 to 14, or some of them. They're some way apart. So what we say is this, that this restaurant is in residential area, but it's also in the middle of an area which is for mixed retail use. People can still go to convenience stores until 10 o'clock at night either side of the road. And the density of housing nearby is some way away. And 17 is a plan that came with the enforcement notice, which again shows the location of the premises. And you can see that there's a number 17 Rock Road to the rear, and then further down the road there are other houses. Now, as I say, no doubt some of the residents of Rock Road, those at 2 to 14 or 17 and the lady in 106A, have concerns about the extension at the back leading to there being more noise for them. But if that's taken away, which is what this application today, we're taking that away, we say that there can't be any reasonable objection to Mr. Dortage to be able and given the opportunity to run a successful restaurant business using the original part of the premises and the front. I want to clarify, there's been some criticism because there was an advert that said the place is open to 11, and I may be wrong, and no doubt Ms. Beebe will correct me, but my understanding of it is the licence application is for permission to serve alcohol up until 10. But quite plainly, the idea of the premises being open till 11 is obviously a natural drinking up and eating up time, because if you can sell alcohol at 5 to 10 in a restaurant, obviously people need time to consume that. So that's why the opening hours are said to be until 11. Now, if the position is that no one can consume alcohol after 10, Mr. Dortage will obviously abide by that. But at the moment, that's our understanding. He will not be serving any alcohol after 10 p.m. Now, I've just got a few more points to clarify. Yes, looking at yes, there have been a good number of evenings where the use of the 10's temporary licence has happened. And it's Mr. Dortage's case that as a result of those matters, there have been no complaints to the police whilst the premises have been open. There have been no complaints to the fire brigade. There have been no complaints to environmental health. There have been no complaints other than the complaints that come from the objector who purports to represent the Upper Rock Road Association. It's not accepted that there has been dancing at the premises. The photographs that show an advert for a belly dancer, that's never happened. It was a promotional idea, but there's been no belly dancing performances at that restaurant. And obviously the photographs in the Shisha Lounge showing people drinking cocktails and using shisha, again, That was before the premises were opened. It was a marketing tool. And it was nothing to do with serving customers and making money. That was part of the promotion. It's not accepted by Mr. Dortage that he has kept the place open late at night. It's alleged that it was open late on the 5th of January. Mr. Dortage tells me he had 4 customers in the restaurant that night, and the last 2 left at around about 9:30. So he doesn't accept this. And what we say is this. Mr. Dortage knows if he's granted this licence that there will be neighbours and residents keen to see and hope that he complies with the requirements. He has a sign in his premises to make sure that remind his customers that when they leave quietly. And when one look at the sort of customer he's trying to entertain, I really think it's far-fetched to think that there's going to be a load of drunken, rowdy people falling out of the premises at 11 o'clock, shouting and screaming, making lots of noise. So, moving on to some other points. As I say, all the appropriate authorities have been notified, and none of them have come back with any objections. So all the objectors, the only issue relates to the planning. And obviously, as we've said, that will be dealt with, and the possibility of an extension of this licence, if granted, is for another day. So if I can just have a moment to take some further instructions to make sure I've not missed anything out of our representations, then I may finish. I'll just double check I've not missed anything out. Yes, one point. Page 9 of the agenda, options. Now, the items that the subcommittee's decision, they have to view this place promoting one of the 4 licensing objectives. Well, the prevention of crime and disorder, there's not a shred of evidence that there's going to be crime and disorder at these premises. Public safety, you've seen the decor, the building. Prevention of public nuisance, we've explained the situation, and obviously protection of children from harm. Again, that seems far-fetched in the circumstances of what this application now is, an application for a middle-tier restaurant. So on that basis, on behalf of Mr. Dortage, who has brought a business to the area that is a good amenity, that could very well be a good benefit to the community. And of course, neighbours have concerns. And of course they've had concerns about the extension. But if you just forget about the extension, focus on the main part of the building and see it as a proper, legitimate restaurant. In my view, this is an application in regards to the main premises that should be granted. Yes, sorry, I've concluded my submissions.
Okay, thank you for that. Councillors, your turn next. Councillor Wade.
Thank you. Thank you, Chair. Mr. Goodliff, yes, I hear that you're saying that your client is focusing on the main body of the building pending the extension. I've got some questions around the photographs as well that you've submitted, thank you. But yeah, I know that you're employing a top quality chef and 10 years lease and £160,000 on renovations. with your business plan, how many covers would there be in the main body of the restaurant, given that the extension's no longer part of the picture? Do you have any idea? Thank you.
We'll get there in the end. 30 are in the main part of the restaurant.
So the seating area is going to be extended then, as shown on the from what's shown on the photos. They're going to be
But there's
rotated.
30 inside the main part of the restaurant, and obviously you've seen from the photographs about 16 seats outside.
Thank you. And has the kitchen been upgraded at all? And I can't see any pictures of the kitchen on the photographs, because it was previously a takeaway. And I note that a top chef's going to be running, and I've had a look at your menu. I'm just wondering if if the kitchen's been upgraded.
So I'm instructed it has. It's got a new canopy, and there have been some silencers located in the kitchen.
Thank you. And to go back to the photographs that you kindly submitted, on page 6, I just want to clarify where you have the second fire exit, and I can see a picture, that's the actual extension starting there with the bench seats, is that correct?
Yes, that's the, yes.
So presumably the kitchen, etc., and the loos are in that corridor?
They're to the, if you look before the sign, do you see the sign at the top?
Yeah.
The red and yellow sign, it's a corridor off to the left. So it's self-contained within the main building, because obviously so there's 2 toilets, as if you look at page 33 of the agenda, we've got the plan, and it shows where the toilets are, the other side of the kitchen, and out the front we have the bar and the 30 seats for people inside the restaurant.
And to move on to page 7, the door that's at the back with the Yale lock, what is that, please?
That's the storage, the other side of that.
Moving on to page 10 of your photographs that you submitted, I understand what your point, but I just wanted to clarify the windows at the back there immediately, as you look at the picture, what is that object in the window next to the fire exit sign?
Is that a speaker or something?
No. These
Yeah.
are just blinds. Blinds.
There are blinds on the windows.
Is that not a speaker adjacent to the window on the right-hand side?
Yeah.
Yes.
Yes.
Thank you. And how many covers potentially would be in the extension for the restaurant?
Yeah. Well, we've got the photograph, haven't we?
There's with the table arrangement, it's about 36 as well.
Yeah, that's about 36. That's 36.
In the extension, 36?
Yes.
In the main
Yes.
restaurant, 30?
Yes. But my understanding, obviously, was the original intention, this was going to be like a relaxing area. But yes, it could, in theory, double the capacity of the restaurant if in due course permission's granted for an extension. But obviously, we're not asking for that today.
Thank you.
Councillor Pounds.
Yes, can I ask, please, when you did ask for temporary licences, what time did you actually ask for the licence to be extended until?
Yes, I'm told they were just until 10 to match what was being applied for in the application for the main licence.
Councillor Blackburn. The floor is yours.
I wish to ask why we haven't been provided with the drinks menu.
Sorry, I didn't catch that question. Could you just ask that again?
We've been provided with a food menu, but we haven't been provided with the drinks menu, so I wondered about that.
Okay, thank you.
My understanding of it is, you know, there isn't a specific drinks list in existence at the moment. Oh, we do? Right. Correct that. Yes, there is a wine list. I thought when I attended the premises, I asked for the food list and I forgot to ask for the wine list. So that's the explanation.
Thank you. I also wanted to ask, how are you upholding the purple flag accreditation?
Sorry, I may have misheard you. Did you talk about a purple flag? My hearing's bad.
Yes, it's an accreditation from the Association of Town and City Management that Cambridge has to uphold diversity and inclusion in nightclubs while also being safe for customers, visitors, residents, cleanliness of the premises and surrounding residential areas for all night entertainment.
This is a night thing, isn't it? Yeah. Yes. Yes. We don't understand the point you're making.
I'm just wondering how you're going to be promoting the safety and well-being of both your visitors and the residents.
Well, this is a restaurant. Mr. Dortage will take all necessary measures as part of any condition of any licence to provide whatever measures are required. My understanding on the application, there's quite a lot of detailed information about CCTV, which we have installed, which is installed.
Thank you very much.
Councillor Pounds, did you have another question?
Yes.
Following your questions, I'm going to ask Councillor Smith to ask. She's got another couple of questions, but I'm saying that so she can hear us, so she knows that she's going to be following
Yes,
you.
thank you. Yes, there's just a couple of things. First of all, can I just say, did your temporary licences cover alcohol then? Because you're talking about a wine list.
Yes, yes.
And could I also please just go back to Officer Beattie and just ask about the drinking up time? Do we normally give a recommendation for drinking up time, because and how whether that is included in the advertising, which seems to have been the case here, or whether you would normally expect people to say that the restaurant closes at not at drinking up time, but when they stop serving.
Usually that is something which is stipulated by the police when they do licence applications and consult upon it. I mean, indeed, the idea with the drinking up time is also in terms of like dispersing patrons quietly and soundly as possible. So yes, it is in place for many premises in Cambridge that there may be half an hour. You have the cessation of alcohol sales, and then there'll be the drinking up time, because the licensable activity is actually the sale of the alcohol. The consumption is not a licensable activity. So as I say, many businesses, even like the big nightclubs in Cambridge, will have that sort of like wind down time, and then they will have a closing time, which is, as we've discussed, isn't enforced by the Licensing Act.
Thank you. So would you expect the advertisement for the restaurant's closing time to be the when you stop the sale, or would you expect the advertisement to include drinking up time?
that is very much down to the business itself, in terms of observing their the planning conditions on there as well, and whatever time it is that they want to close.
Thank you.
Councillor Smith.
Thank you. I have several questions. So is it better to take them one at a time, I'm assuming?
Yeah, I think the consensus is one at a time would be good. I know we generally
Okay.
ask blocks of 3 and so forth at council meetings, but if that could, would you prefer one at a time? Yes, we're getting nods. One at a time, please, Anna.
Thank you. So first of all, I want to come back to the issue of the photographs. Now, as a local councillor, I would have welcomed the opportunity to present potentially additional photographs to balance and clarity, because they are very carefully chosen photographs. So I wish to ask again why photographs have been submitted at such late notice, given their centrality to the presentation we have just heard from the legal representative.
I've only been instructed in the past few days, and it's obviously, I realised that there was a pressing need for there to have some photographs of the premises. What I would say is I don't think that they're hand-picked photographs. In fact, we include photographs that show aspects relating to the extension, which perhaps some more devious lawyers might have left out altogether. But I've tried to show the entire picture. I've also shown the front of the premises, and I've tried to give a good representation so that the councillors can see what type of a restaurant this is going to be.
Thank you. I personally would have preferred something that showed a little more of the surrounding residential properties, of which there are several on the road. But setting that aside, I've got a couple of questions about noise, which I will make together, if that's okay. They're two linked questions. So one...
Anna, can I stop you
what
just?
is your-
Anna, can I stop you
Sorry.
just for a moment? Would you please just get a little closer to the microphone? You're sort of fading in and out a bit.
Okay, that's...
Thanks.
Let me see what I can do. I've actually got headphones in, so can you hear me better now?
Yeah, it's about strength 6, but
Hang on,
we're all
hang on.
okay with
Wait
it.
a minute. Okay, if I go via the speakers rather than my headphones, is that better?
Yeah, that's clearer. Thank you.
Okay, we'll do that. Thank you. So I have two connected questions on noise. Firstly, what assurances can be provided, given the noise already being reported as coming from the premises, that sound will be kept to a reasonable and acceptable level? And secondly, can the applicant give assurance that no one, either customers or staff, will be outside the rear of the restaurant if that lounge area is not open at the back? Because what I'm getting from residents is that it's also being used as a kind of bit of a chill out space. So can we have absolute reassurances that people are not going to be standing outside of that space, either customers or staff?
There isn't any space outside.
Bin storage.
Hey?
There's bin storage.
Yeah. Okay. Yes. The extension fills up virtually the entire backyard, except for the fact that there's bin storage at the back. So members of staff would need to take the rubbish out to the back. There's a very limited small area that is actually outside. The main purpose would be to take the rubbish out.
Thank you. And the other connected part of that question, which was the assurances that can be provided that the sound will be kept to a reasonable level.
Yes, the point is that the sound will be kept to a reasonable level, and the positioning of the amplifier or the existence of it will be taken on board by Mr. Dortage, and it's unlikely that there will be music of any loudness played in the back room.
So, Chair, please stop me if I'm asking too many detailed questions here, but I'm already hearing, so residents that I'm representing live above the premises, and they are already reporting to be very significant noise levels. So what is going to be changed to reduce those noise levels for the residents?
Well, the thing that's going to change immediately is the fact that the lounge which has been used under the temporary licences is not going to be used. The vast, if not, I'm guessing that virtually every complaint relates to noise emanating from the rear extension, where there are parts of it which can be retracted, and the nature of the structure. That is not going to be used unless and until appropriate planning permission is obtained, and then an extension to the proposed licence to the main premises. So that's the situation. There should be no reason for there to be substantial noise coming from the extension at the rear of the premises.
I'm sorry, Chair, I'm clearly not being very clear on my question here. I'm not asking about the extension. What I'm asking for is the noise that is coming up through the floors from the kitchen and from the interior spaces, and what is going to be done to ensure that the residents are not having that noise nuisance moving forward.
Yes. The kitchen's been in existence for over 30 years. And back in 1994, when the original planning was obtained, investigations showed that the kitchen of the then takeaway and the customers toing and froing into the takeaway area, that there was no need for any additional noise restrictions. And that has been the position that's been maintained ever since. I'm also told that if there was a thought that there was unacceptable noise coming downstairs from below, the occupier above has the remedy to invite the authorities to do testing to see if there's a statutory nuisance with too much noise. And that's her remedy. But the point is, it's been looked at in the past, and the issue of noise, it's been found that there's no need for the occupier to have any additional protections. I'm also told that there has been a van that's recorded sound, and they have confirmed, is that right? Oh, sorry, all right. They haven't. All right, sorry. Forget that last point. I've misunderstood my instructions. I'm also told that there are two silencers put on the extractor fans to reduce noise of the neighbours. I'm also told that complaints have been made by the occupier in the flat above about the noise from the extractors at times when the extractors have not been on for long periods of time. In actual fact, there are premises 2 doors away which have noisy extractor fans of an old-fashioned nature, which are the extractor fans that make any noise if that occupier hears noise from extractor fans.
Chair, could I make a clarification? Having looked at the submissions to this, there is more than one occupier above that flat, and I'm very concerned. I know in the submissions that there was a requirement to keep people anonymous. So referring in any way to individuals within that, I think we should just be slightly careful about how we phrase that, so that, because I know that that was a specific request. Okay, well,
I won't proceed that line of questioning further. I am concerned. I know that there was a kitchen and an extractor before, which I know people felt were causing less noise. So I do remain unconvinced about what might be done to improve that noise nuisance. But I wanted to ask, if I may, two more questions. First of all, Councillor Wade asked about covers, and I understand 30 covers inside, 16 outside, a potential of another 36 additional cover. Sorry, yeah, 16 at the front, a potential of 36 additional covers at the back. Is the 30 inside and the 16 at the front sufficient for the premises to make money long term, or does the business plan depend on those additional 36 covers outside at the rear of the property?
Yes, that Mr. Dortage is confident that, albeit in the perfect world, the whole of the premises, including the extension, would be available for use, but he is confident that he can make a success of this business using the main building and the front.
Thank you. And I do have one further question. And that question is, I just wonder if I'm sorry, I don't know the name of Mr. Dortage's legal representative, so I'm not trying to not use names. It's just that I didn't hear it. But I wonder if Mr. Dortage's representative might like to consider withdrawing the suggestion, which I heard quite strongly, that somehow residents are complaining because they are snobs or worse, and that somehow because it's a nice restaurant, they won't mind, and they're worried about there being just another Indian restaurant, because we have some absolutely outstanding Indian restaurants in that part of the ward, and I'm sure that residents would not wish to be accused of snobbery in this regard. This is not about anything of that nature.
Well, forgive me if I said the word snob, but I'm pretty certain I didn't. As I say, all I've tried to put across is that it's an amenity to this area to have a traditional sit-down restaurant, as opposed to takeaway venues of whichever nationality of the food that is provided by those other places. I'm sure they are all good establishments, but this provides an opportunity for a proper sit-down meal.
Thank you. That's it on my questions.
Okay, thank you for that, Councillor Smith. Now, I've allowed such a round of questions because there is so much public interest in this. It was in the public interest, I believe, to extend that beyond that we would normally do, and I think that was important for those councillors who've turned up to represent their residents to have their say. So I'll make no apologies for the fact that there were a lot of questions there. I think it was important, and it also gives the applicant time to respond to those concerns and worries. So everybody's had a fair crack at the whip. However, there will be time for each member to have a very short summing up and to clarify any points. So you will get another short round, but before we do that, I'm going to ask the licensing officer if you have anything to add to that or anything that you would like clarified on what you've heard so far.
The only thing I'll say is that the 10s that were applied for, I believe it was to 11 p.m. in each case, not 10 p.m, but it's a very small point.
Okay, thank you for that. I've got one. It's not so much a question, because generally, as Mr. Goodwill will know, I normally ask quite a number of questions, but in fact, we've had most of what I would have covered. But I will say that as you've made the offer not to use that extension, I'm assuming should planning permission be granted, and that needs to come, or your clients wish that to come back into full use, you would have to apply for a licence for that extension. Am I right in that?
Yes, they could apply for a variation to include the extended area.
Yeah, that's my point really, Alex, is that should it be granted at this stage, we're not preempting anything, but should it be, then it won't automatically, we just understand that that won't automatically
Yes, we fully understand that there would be a need for a variation or fresh application, but as I say, until we know the outcome of that planning application.
Just wanted to make that clear.
Yes.
Thanks, Graham. As long as everybody understands that, that's fine. In that case, Councillor Blackburn, do you have any end comments, a couple of minutes just to wash up, or any clarification or anything you think you may well like to have said and haven't?
Nothing I can think of, thank you.
Councillor Smith, the same question?
Yeah, I do have a couple of points I'd like to raise which haven't come up in the questions. So thank you. I'll try and be as brief as I can. I would just like to repeat the fact to someone advocating on behalf of local residents that receiving papers at the last minute is not ideal. It really doesn't help us support. I should point out this premises, as we've heard, has been a takeaway premises in the recent past. Residents are used, therefore, to a reasonable amount of noise that is connected with the food residents premises. They're used to extractor fans. They're used to have a kitchen below them. They're used to people standing outside. So I think that is important context here. I'd also want to point out that Cherry Hinton Road does have a diverse range of shops and restaurants. They add a lot to our area. Residents are not in principle opposed to the idea of shops and restaurants. And as local councillors, we are also supportive of local businesses. This is not about not wanting a business here or not wanting the applicant to succeed in their business ventures. This is about the particular issues that residents are sharing. I've raised my concerns about the idea that residents want this to be a nice place and that would allay their concerns. This is about the noise. This is not about who may or may not be using the restaurant. It's about this particular licence. Now, the public nuisance that is already taking place since the premises that has opened, that I have had reported to me, is creating significant concern about the additional granting of an alcohol licence. So I am being told that people in the flat above can hear pretty much every word in the kitchen, and that wasn't the case in the previous premises, that the sound is causing vibrations in the flat. There must at the very least therefore be significant improvements to the soundproofing to support the residents who live above. The noise frequently is currently happening from lunchtime until around about 11 o'clock on weekdays and after midnight at weekends. And this is coming up through the floor and through the windows at the front and the back. So it means that the residents are telling me there is an impact on the health of some of the residents living above that flat, that premises. Even when there is no noise at a given time, they're anxious about when the noise might start, and this is preventing appropriate, quiet enjoyment of their home. And they're very concerned about the increased noise that could come from an alcohol licence. I've also heard some reports of an increase in littering, especially cigarette butts, outside of the premises at the front, and some concerns also about food odour, although I understand that's not material here. I would also like to return for the issue of the nature of the street. It is a mixed-use street. Yes, there is retail, but the photographs of the surrounding area, in my opinion, do not fully represent the amount of residential properties that are also on Cherry Hinton Road. It is not just about the side streets. And I think that's very important to give us clarification for members of the panel, because it could otherwise have the impression being given that this is a purely retail strip, and it is not. So that's all I want to say. I'm very grateful for the opportunity to speak on behalf of residents today. And I'd also want to thank the applicant and his representative for taking the time to answer the questions in so much detail.
Yeah, thank you for that, Councillor Smith. I can tell you that I'm very well acquainted with that location, been past it very many times, so I do know the area well. Councillors by my side, Councillor Pounds, have you anything to wash up? Councillor Wade.
Yes, please, if I could, Chair. Yeah, and I'm to reassure Councillor Smith and the other councillors, I once lived on Cherry Hinton Road, so I'm very au fait with the area. Can I just clarify that this is the first time that this property has been used as a restaurant as opposed to a takeaway? Because obviously there are different noise levels incurred. It's a change of use to a restaurant. This is the first time?
Yes, the previous takeaway was essentially a takeaway, but there was some seating for a few people to be able to sit in the front of the premises and eat.
Thank you. And I have one more clarification question. You talk about there's a top-notch chef, etc., and 8 staff up to now that have been employed, thankfully. As Councillor Smith said, we like to encourage local businesses, but I assume that's based on all the covers, including the extension.
As I said, the original plan was that if the whole premises were available with the hope of filling the restaurant such that both bits would be used, the hope was to get up to 12. I've indicated that 8 members of staff have been used for these temporary nights. One would anticipate that number may not go up in light of the lesser availability of covers, but one also has to be realistic as to that times are hard. This is not. This is quite a special evening out type of a meal thing, special occasion type of a meal. One would have thought. So it's more quality than quantity. So I would have thought that if it's required 8 people up until now, even if the lounge at the back is redundant, nevertheless it will still require up to 8 people to keep the place going.
And by your indication, Councillor Blackburn, I'm guessing because you didn't get to have a comment on the summing up that you suddenly thought of something.
I'm sorry, I did have a statement I intended to read. Apologies for that. The Queen Edith Ward Councillor's objections to this licence was accepted as valid under one or more of the 4 licensing objectives outlined within the Licensing Act 2003 and sits alongside Cambridge City Council's own licensing policy and planning regulations due to change of use of this premises with the she use creating a mixed use of this property which requires planning permission as does not fit with its current registration as Class E. The Institute of Alcohol Studies states it wants to see licensing support diverse, inclusive and sustainable communities without undermining local areas and putting undue pressure onto the public sector. Alcohol is used and enjoyed by many, but it can also be the cause of significant social and personal problems. Licensing should have a key role to play in addressing and preventing many of these problems. I am raising an objection to the application for an alcohol licence to 106 Cherry Hinton Road because the licensing objectives, this include preventing public nuisance, has not been met. The prevention of crime and disorder. Residents are concerned that failure to consider the wider circumstances of this application places risks on residents to deal with the consequences of noise and nuisance, prevention of any disorder which may lead to crime by this venue operating in this way in a residential area, that it does not fit within the Purple Flag accreditation for safety of visitors and residents. The opening times on the application do not relate to the current advertised opening hours, indicating the business will be open until 11 p.m. Monday to Friday. Residents have reported customers leaving at 12 p.m. weekdays. It is also not clear how in practice that last hour of operating potentially licensable activity would be enforced. ISA states late night opening has spread crime and disorder back into the early hours, causing significant problems for the police. Most police forces had to rearrange their shift patterns and allocate increased resources to the nighttime economy to address this change. Parking is a key creator of antisocial behaviour in Cambridge. and with this venue abutting and within residential roads, attenders of the premises are likely to choose to park on the residential roads, not the main road, where there is limited legal parking, creating late-night noise and risk to residents. There is evidence of these antisocial behaviours by the Rathmore Club. Public safety. What other measures are being taken to aid the prevention of crime and disorder, to ensure public safety, to prevent public nuisance, and to put in place measures for the protection of children in this residential area from harm? How is the applicant resourcing, implementing, and reviewing these for their effectiveness? The main part of the premises to be licensed appears to be an extension. This extension directly abuts residential family housing as it is surrounded by residential properties. A previous HM Planning Inspectorate report into a proposed late-night takeaway use for this property refused the application, concluding residents of the area should be free from unnecessary disturbance at times when they should enjoy a greater degree of peace and quiet. Has a subsequent planned application been submitted and approved? The premises is Class E, which is not for the purpose of its current usage. A residential area with children surrounding it in flats and houses is not suitable for a premises with a bar serving alcohol and shisha, live music and dances. The prevention of public nuisance. The alcohol boundary detailed on the plans does not clearly delineate the building boundary. The plans submitted may not be in line with the demise of the property and may require further review. How is this extension to be blocked off, and how will this not be used? How is the alcohol boundary going to work in practice? What resources are being put in place to ensure the above is upheld and review its effectiveness? The policy also requires that measures are followed. For example, applicants should consider to control noise nuisance from the premises, should include sound limitation devices, acoustic lobbies, acoustic double glazing, noise insulation, and should ensure non-amplified, allowing only acoustic music. The extension currently has a retractable roof that fully opens, is open on one long side, while the walls acoustically dampened as if these are not, factors appear not to meet the licensing measures required above, where in the application have these required measures been demonstrated. The key licensing objective is to prevent public nuisance. What measures are being taken? Is it only a notice requesting customers to leave quietly? The rear extension is under investigation for enforcement action by the Planning Department. If removal is enforced, then I would ask until that time no license is granted for this area of the premises. This is to avoid inappropriate drinking, music, entertainment, dancers being in an open area, creating more nuisance to the neighbourhood residential roads. The protection of children from harm. The application for an alcohol licence is in a premises that intends to run as a late night drink and shisha bar, which has already featured live entertainment dancing. This is inappropriate as it is adjacent to and in a predominantly residential area with many family homes with young children. Cambridge City Council outlines protections it applies for residents in its licensing policy. Stricter controls on noise control are likely to be imposed in the case of premises that are situated in predominantly residential areas. This business abuts a family residential property and sits within a family residential area. A licence for alcohol until 10 p.m. weekdays does not support the Council's Community Safety Partnership aim to work proactively to stop antisocial behaviour and nuisance noise. IAS states there is a need to protect wider environment in which alcohol is licensed so it does not unduly undermine society and lead to health and social hazards. The premises have already had an alcohol licence turned down as the council felt it would be a public nuisance, and that was for the front shop only. Thank you for your time.
Okay, thank you for that. That leaves us with Mr. Beebe. Have you anything you'd like to add, wash up, clarify?
In terms of summarising the matter, okay. So the decision before committee today is to determine the new premises licence application for Sunset Lounge 106, Cherry Hinton Road, Cambridge, having regard to the licensing objectives and the council's statement of licensing policy.
Thank you very much. And as ever, Mr. Goodwill, in the interest of fairness, you have the last word.
Yes, I would just like to deal with some of the points raised by one of the councillors. There was a lot of specific allegations relating to noise emanating from the kitchen. The occupier above the premises, if she has a legitimate case to argue that there's a nuisance there, she has the appropriate remedies to have it investigated by the environmental health for the sound recordings to be taken and for the matter to be investigated. That should not be that's a private individual remedy. That shouldn't be something that's used in relation to the general licensing application, which the licensing committee is due to take on board, which is much more of a general issue than the matters raised by the councillor. And I should also say that the councillor criticises the applicant because some documentations had turned up late, but there's absolutely nothing specific in any of the written documentation about those complaints about the kitchen with any of the paperwork supplied by the objectors. And so I think it's unfair that she's raised those points. I would also refer everybody to the photograph 15, which shows the back of the premises, and it shows that the cylinder at the back has 2 large silencers fitted to it. So when the improvements were made to the kitchen and the improvements to the cylinder at the back, the extractor, appropriate advice as to what was necessary to minimise the noise has been taken and been complied with, and it's there. As I say, the position is this. The application is for a restaurant licence, ideally to include Sundays as well as Monday to Saturdays, and to be from midday until 10 o'clock at night. And you've heard the plan. The restaurant will close at 11, allowing people an hour to drink up, eat up, and leave quietly. Yes. It's 12 noon until 10 at night to sell alcohol, and with an hour drinking up time when the place will close at 11.
Okay, any clarification, anything you need to say, Elizabeth, from a legal perspective? Yeah, that's fine. Is everybody happy that they've had opportunity to say everything they needed to say before we adjourn? Going once, going twice? Okay, thank you everyone. In that case, the subcommittee now discuss their decision in private. We will seek some legal advice, but just to clarify, that legal representative does not actually have anything to do with the final decision. We will just seek clarification on various points of law or some of the content of the report. Decision needs to be given within 5 days, that's true, but we will retire now to our deliberations, and if it seems that we're not able to make a decision today, we will come back to you. So if you give us 1 hour clear, and at the end of that time, we will tell you whether we're going to be able to come to a decision today or whether that decision will be deferred. Everybody happy with that? Thank you so much. Okay, thank you very much, everyone. We've managed to come back on the same day we started, so that's always a bonus. I'll just read off what I've got here, and as always, you'll get a copy of that. So those members present that took the decision are here in front of you. We took legal advice, but the legal representation was not part of the decision-making process. It was purely to guide us along those legal lines. We heard representations from the following persons. Alex Beebe, Licensing Officer, Cambridge City Council, your good self, Graham, Councillor Anna Smith and Councillor Blackburn Hogan. The reasons you appear before the subcommittee was consider the application for a premises licence to provide sale by retail of alcohol Monday to Saturday, 11 a.m. to 2200. In making our decision, we considered the following: statutory provisions, Licensing Act 2003, statutory guidance, Cambridge City Council statement of licensing policy, and reports submitted. Advice from legal officer and representation from Councillor Anna Smith, Councillor Blackburn Hogan, and Mr. Goodwill on behalf of the applicant. We consider evidence from extra evidence. The panel allowed late evidence consisting of photographic evidence and a plan of the location of the restaurant from the applicant, and we considered evidence from residents. We found the following: extensive representations from residents, statements from councillors representing residents, change of use from takeaway to restaurant, and when questioned, there were little or no mitigations or intended alterations to nuisance caused by the residents. Licensing objectives: the granting of alcohol licence brings with it the right to play music. Page 10 of the additional evidence shows a speaker next to a window which shows existing potential disregard to residents. Up until now, the Sunset Lounge has been represented as a shisha bar with amplified music and dancing in the promotional material. The sudden change in the narrative to a quiet family restaurant raises concerns going forward as to the actual use of the venue. No positive responses were provided to residents, councillors' noise concerns. Residents' objections appear to be disregarded and no goodwill was shown to address their concern. Neither the application nor the representations provided any adequate measure to reduce noise nuisance. Significant use of the TENS suggested that intended use of the venue as a bar as opposed to a family restaurant. We did not consider the following matters to be relevant: renovation costs, substantial changes to the application, the fact that the application no longer includes extension as part of the application is irrelevant as it is subject to planning enforcement. Our reasons for this are: the cost of the renovation is not a licensable consideration. The new additions did not form part of the original application. The fact that the extension is not going to be used as mitigation to allow this application is relevant to page 53, section 3, where the senior compliance officer states that it is subject to a compliance investigation which will shortly result in enforcement action. This is therefore not for consideration as a licensing objective or mitigation from the applicant. We consider all evidence to be relevant, including the late submission of photographic evidence by the applicant's representation. Our decision is follows. Our decision is to refuse the granting of alcohol licence to Sunset Lounge of 106 Cherry Hinton Road, Cambridge. Our reasons for reaching decision are as follows. We do not consider that the current application supports or promotes the 4 licensing objectives. The historic use of the TENS licences would indicate the future aspirations of the current owners. Residents' concerns have not been adequately addressed, and that concerns the response, and there will of course be copies for you. Thank you, ladies and gentlemen. That concludes our meeting today.